As Donald Trump's sweeping tariffs go into effect, we are waiting on a ruling from a federal appeals court that may answer a crucial question. Are the bulk of Trump's tariffs even legal? During a lengthy legal argument on Thursday, federal appeals court's judges seemed skeptical that Trump had the power to bypass Congress and impose tariff rates around the world by using a 1977 emergency law. Joining us now is the lead lawyer who argued the tariffs case against Trump's executive order, former U.S. Acting Solicitor General Neal Katyal, professor of law at Georgetown University and an MSNBC legal analyst. Neal, thank you for joining us. I want you to take a listen first of this thought, talking specifically about the exchange between the judge and the U.S. attorney from Trump.
Legal dispute erupts over Donald Trump's historic tariff executive order. In the modern history of the United States, no president has unilaterally imposed large-scale tariffs on imported goods from around the world until Donald Trump declared it necessary for national interests. In early 2025, amid a global economy striving to recover from multiple geopolitical shocks and supply chain disruptions, a unilateral decision from former President Trump ignited a fierce wave of controversy. Relying on the National Emergencies Act of 1977, a law born during the Cold War era, Mr. Trump signed an executive order imposing new tariffs on hundreds of imported goods without congressional approval. The reasons cited, the prolonged and rapidly increasing trade deficit over the past 4 years, has become an extraordinary threat to national security and the domestic production capacity of the United States. However, these arguments quickly met with vehement opposition from scholars, economists, businesses, and especially the judiciary. Last weekend, an important hearing at the Federal Court of Appeals drew significant attention as judges repeatedly questioned government representatives about the constitutionality of this executive order. Can a president unilaterally declare something a national emergency to bypass the checks and balances clearly stipulated in the Constitution? That was the question repeatedly posed in court. Neal Katyal, former acting Solicitor General of the United States and currently a law professor at Georgetown University, who leads the legal team opposing the tariff executive order, called Mr. Trump's action unprecedented. Speaking at the hearing, he emphasized, no president in history has interpreted this law the way Mr. Trump is doing, and if this precedent is accepted, it will open a dangerous door for any future president to act like an economic dictator. Observers believe this is not just a trade lawsuit, but a test of the limits of executive branch power within the U.S. system of separation of powers. If the court declares Mr. Trump's executive order unconstitutional, it will be a heavy blow to the expanded executive power doctrine that he has used multiple times in his previous term. Conversely, if the court sides with him, it will set a worrisome legal precedent for the future of American democracy. While America awaits the court's ruling, international public opinion is also closely monitoring. Is the Washington administration entering a new era where tariff and national economic decisions are made not through congressional votes, but merely with a signature from the White House? At the tense multi-hour hearing at the Federal Court of Appeals last week, judges repeatedly expressed skepticism toward the government's arguments. The representative from the Department of Justice, lawyer for former President Trump, asserted that the trade deficit in recent years has exceeded normal levels and seriously impacted the U.S. defense production capacity, thereby constituting an extraordinary threat as stipulated in the 1977 Emergencies Act. However, this argument was quickly rebutted by the plaintiffs, led by lawyer Neal Katyal, in a sharp presentation before the panel of judges. Mr. Katyal pointed out that the trade deficit figure cited by the Trump administration, specifically a 40% increase, is actually unadjusted for inflation. When converted to real value, the increase is only about 15%, completely within the normal fluctuation range of the U.S. economy over many decades. Not stopping at data, Katyal also emphasized that even in Mr. Trump's executive order itself, it once acknowledged the trade deficit as a phenomenon persisting for 50 years. This, according to his argument, completely contradicts the requirement of extraordinary and unexpected nature, the key condition to activate emergency powers under the law. Throughout the hearing, the judges did not hide their doubts. One judge asked, does a trade deficit persisting for decades suffice to declare a state of emergency? And if this is an emergency, then what cannot be declared an emergency? The situation became even more intense when the government side asserted that the authority to determine a state of emergency lies entirely in the president's hands and that court intervention could infringe on executive branch powers. In response to this argument, the judges clearly expressed their view. The law itself does not grant such unlimited authority, and if the president can invoke any reason, even, as one lawyer once quipped, a shortage of peanut butter, to declare an emergency, then the entire constitutional checks and balances mechanism would become meaningless. Lawyer Katyal also cited historical precedents to bolster his arguments. He noted that even during the U.S. Civil War, when Congress granted President Abraham Lincoln many special powers for defense, the imposition of taxes was retained as an inviolable prerogative of Congress. From the time of the Revolution, Americans have understood that taxation is a field too prone to abuse by a king or a strong-handed leader. Therefore, the Constitution clearly stipulates only Congress has the power to impose and collect taxes, he said. In this case, Mr. Trump's tariff executive order is not just an economic policy, but has become the fulcrum for a principled legal dispute. It forces the judicial system to confront a core question. Does the U.S. Constitution still have the capacity to prevent overreach by the executive branch? Although the Court of Appeals ruling has not yet been announced, many legal experts believe the case will certainly be appealed and brought to the Supreme Court. With its particularly serious nature and rare precedent, this will be one of the largest legal files related to the separation of powers in many decades. According to the National Emergencies Act of 1977, the sole legal basis Mr. Trump invoked, the president is allowed to take certain special actions in situations determined to be extraordinary and serious. However, the law provides no specific definition of what constitutes an emergency, nor does it require the president to obtain congressional consensus or fully prove the criteria. This legal gap has created conditions for presidents, especially Mr. Trump, to stretch the scope of executive power in ways beneficial to themselves. Lawyer Neal Katyal emphasized that the ambiguity of the law is what is alarming. He quoted from the lower court trial, where one of the lawyers representing the Trump administration once stated that a shortage of peanut butter could completely be considered an emergency reason. Though satirical, it captures the real danger. If the president is the sole definer of what is an emergency, then the checks and balances system is effectively neutralized. Katyal argued, no one denies that the president needs flexibility in times of crisis. But flexibility does not mean absolute power. When an action has profound impacts on the entire economy, like imposing tariffs on imports worth hundreds of billions of dollars, then there must certainly be clear consensus from Congress. In fact, no U.S. president in history, even in wartime, has unilaterally imposed a large-scale tax policy like Mr. Trump without going through Congress. During the Civil War, Congress granted President Lincoln the power to blockade maritime routes for military response, but still upheld the principle all tax decisions must be approved by Congress. This is not only tradition but also a constitutional principle stemming from lessons in the American Revolution, when colonial people strongly opposed being taxed without representation in the British Parliament. The debate over presidential power does not stop at theory. It has created real impacts in many recent policy files. The U.S. Supreme Court has repeatedly rejected broad power claims from the executive branch, notably, the ruling that the Environmental Protection Agency, EPA, cannot unilaterally expand its authority in emissions management without clear congressional consent. Or most recently, the rejection of President Biden's student debt forgiveness plan for exceeding the scope of an old law. These rulings are based on a principle called the major questions doctrine. Accordingly, if a policy has major impacts on millions of citizens and changes the national policy structure, the president cannot act unilaterally without clear, transparent authorization from the legislative body. Katyal believes that Mr. Trump's tariff executive order is a typical example of the executive branch attempting to read power into an outdated law, something the Supreme Court has repeatedly rejected. If this precedent is recognized, he warned, every ambiguous law could become an excuse for any president to bend the Constitution for personal goals. His statement serves as a warning bell. When the law leaves gaps, power tends to fill them, but unchecked power, even under the guise of emergency, always carries the risk of disrupting constitutional order. Beyond the legal dispute, what concerns U.S. public opinion the most is the economic consequences that Donald Trump's tariff executive order brings to tens of millions of households and businesses. With a scale assessed as the largest tax increase in a generation, the executive order not only reshapes trade policy but also challenges affordability, investment, and livelihood stability for Americans. According to statistics from the National Economic Institute, the broadly applied new tariffs could increase average costs by about $1,300 per year for each U.S. household. This is not a hypothetical figure but has been verified through cascading impacts, from input material prices, consumer goods prices to business operating costs. Many experts describe this as a form of hidden tax increase that American consumers must bear. While the initial goals of the executive order remain unclear in effectiveness, notably, some items subject to the highest tariffs are everyday consumer products like washing machines, construction steel, electronic components, and imported equipment serving domestic manufacturing industries. This leads to a double cost increase phenomenon. Businesses must pay more to import materials, then are forced to raise selling prices, causing consumers to suffer double harm, both as buyers and as workers in affected industries. Economists also raise big questions about the reasons Mr. Trump cited in the executive order, protecting domestic production and national defense. While there are legitimate concerns about the U.S. economy becoming increasingly dependent on foreign-produced goods, there is no evidence that such widespread tariff increases will improve defense capabilities or industrial self-reliance. In fact, according to the Congressional Budget Office report, during the period when Mr. Trump applied similar tariff policies at the end of his first term, many domestic industries, especially automotive and consumer goods, recorded declines in profits and productivity due to rising input costs. On the other hand, major U.S. trade partners, typically China, Europe, and Canada, also imposed retaliatory tariffs, putting many key U.S. export products, like agricultural goods and machinery, at a disadvantage in international markets. Harvard University economics professor Jeffrey Frankel commented, "When an executive order shakes global supply chains and causes consumer goods prices to escalate, it is not just a trade decision, but a decision on income distribution. Who pays the price? Who benefits? The next question is, who truly benefits from this policy? Some large U.S. industrial corporations, especially in steel and aluminum, may gain short-term benefits from limiting competition from imports. However, this benefit does not spread across the entire economy and is largely assessed as localized benefits rather than a comprehensive strategy. Meanwhile, consumers, especially low and middle-income groups, face the risk of skyrocketing prices and potential job losses if businesses scale down or relocate production abroad to avoid tariffs. Not stopping there, the unilateral imposition of tariffs has also led to accusations that the United States is violating World Trade Organization (WTO) regulations, damaging its international image and placing America in confrontation with traditional economic allies. From a public policy perspective, this executive order raises questions about transparency and openness in the economic policy-making process. When a decision affecting hundreds of millions of people is made without going through congressional discussions, where representatives voice voters' concerns, is it still true public policy? In summary, despite being wrapped in politically charged declarations like protecting American workers or regaining fairness in international trade, Mr. Trump's tariff executive order is exposing an uncomfortable reality. This is a policy where a minority benefits while the vast majority pays the price. Amid a wave of sharp criticism from economists and skeptical reactions from the legal community, a question continues to be raised by observers. Why did Donald Trump, who once signed major trade agreements with China and Mexico in his first term, suddenly revive a widespread tariff strategy in his presidential re-election bid? The answer likely does not lie entirely in trade models or economic theory. It lies in political calculations, which have shaped Mr. Trump's campaign since his first entry into the political arena. In a recent interview, when asked why he did not implement this tariff policy right from his first term, Mr. Trump replied, "Because back then, I had to fight a bunch of crazies, those who always do everything wrong to a legitimately elected president." That reasoning offers no economic argument but is heavily confrontational and personally obsessed with political opposition. But in reality, As lawyer Neal Katyal pointed out, in his first term, Mr. Trump once tried to bring a draft granting tariff authority to Congress, and it was rejected. Now, even with the Republican Party controlling both houses, he still chooses to bypass the traditional legislative process, reverting to an outdated law like the 1977 Emergencies Act. The reason may lie in the urgency of a campaign that no longer has time to wait for congressional procedures, or simply, he is not sure of receiving the necessary support from fellow party senators. Mr. Trump's strategy is based on an image, the strong-handed leader, unafraid to confront traditional institutions, ready to break molds to protect Americans from globalization. This message once brought him victory in 2016 and remains the core of his current campaign messaging, reviving the tariff policy, despite knowing it will face fierce backlash, is a way for him to affirm that he has not changed and is still the outsider daring to challenge the old order. Yet precisely because of that, many question whether this is an economic policy or merely a campaign tool. Does Mr. Trump truly believe in the long-term effectiveness of the tariff executive order, or is he simply using it as a political flag to evoke emotions among voters in industrial states that once helped him win? Not to mention, using the state of emergency reason to issue an economic policy reveals a risky governance model, where legal processes are overshadowed by immediate political needs. If this trend continues, checks and balances institutions may become obstacles to overcome rather than the foundation of a solid democracy. Internally within the party, this move is also seen as an effort to consolidate Mr. Trump's personal power within the Republican Party. Despite widespread support among conservative voters, he still faces implicit criticism from traditional-minded senators who worry that his unilateral and confrontational strategy could cause the party to lose control in swing states. Issuing resonant policies like the tariff executive order is part of a larger game, affirming personal influence, pushing back moderate voices, and maintaining a central role in the party's agenda. From an external perspective outside the U.S., this executive order also sends a clear signal that, if Mr. Trump returns to the White House, the America First policy will be pushed harder than ever. Even ready to disregard international laws and multilateral commitments, this causes concern among global investors and allied nations who once took years to adapt to rapidly changing trade policies under Trump. Nevertheless, for Mr. Trump, risk may be the leverage. In a campaign already full of volatility and controversy, a shocking tariff policy may be what he needs to dominate the news headlines and reset the question: who truly controls America, the political elite or the action-oriented leader? Donald Trump's tariff executive order, on the surface, may be seen as a short-term trade policy, but overall, this is the next hotspot in a chain of cases sparking foundational debates. Is the U.S. president seizing too much power? And what are the necessary boundaries to maintain balance among the three branches of government? For many years, the U.S. Supreme Court has gradually affirmed a firm stance in preventing the trend of expanding executive power through flexible interpretations of old laws, especially in recent decades. As both parties take turns trying to stretch presidential authority to implement controversial policies, the court has repeatedly signaled that a major decision cannot rely on vague provisions but must have clear and transparent authorization from Congress. This principle is shaped into a legal doctrine called the Major Questions Doctrine. Accordingly, if a policy has profound impacts on the economy, society, or lives of millions of citizens, the president cannot self-interpret power from a law that does not directly mention it. Instead, Congress must be the sole entity to greenlight it. Typically, the court once rejected President Biden's student debt forgiveness plan for lacking a solid legal basis in existing law. Before that, the Environmental Protection Agency was also blocked when trying to apply broad emissions regulations based on an old law that did not specify. In all those rulings, the core argument is the same. Executive agencies, whether the president or a department, do not have the right to self-decide major questions of the nation. With this tariff executive order, the situation is no different. Mr. Trump invoked the National Emergencies Act of 1977, a law designed to respond to sudden threats like war, terrorism, or cyber attacks, but used to deploy an economic policy on a scale of hundreds of billions of dollars. Notably, the law does not mention tariffs at all, and no previous president has used it for this purpose. Lawyer Neal Katyal commented, "The Supreme Court has repeatedly made clear, no one can read great powers out of a law not written for that goal. If this executive order is upheld, it will erode the constitutional principle that Congress, not the president, is the one to decide on taxes." What is worrisome is that, although appellate judges appear skeptical of the government's arguments, many experts still warn that if it fails at this level, the Trump administration could quickly bring the case to the Supreme Court via emergency mechanisms known as the shadow docket, rulings issued without full hearings. However, in the current Supreme Court, though considered conservative-leaning with many justices appointed by Mr. Trump, boundaries on executive power are often tightly maintained. Justices like Neil Gorsuch or Amy Coney Barrett have issued many rulings showing vigilance against presidents, even those who appointed them, using vague laws to expand power. The question is, if the Supreme Court decides to handle this case, will they maintain the stance of protecting separation of powers or create an exception named Trump? For the American judiciary, this is no longer just a lawsuit, but an opportunity to reestablish limits on executive power in an era where concentration of power in individuals is increasing, not only in the United States but worldwide. The court's ruling, whichever way, will certainly create a decisive precedent for future generations of leaders. In summary, the tariff executive order is not just a political move or an economic decision, but a stress test for the U.S. Constitution. In that test, not only is Mr. Trump being evaluated, but the judicial system, as the ultimate gatekeeper of democracy, must also answer the question, do they have enough courage to set limits on absolute power? Donald Trump's tariff executive order, ultimately, is not just a dispute revolving around an outdated law or a specific trade policy. It is a real and tense test for the entire U.S. constitutional system. Can the checks and balances mechanisms left by the Founding Fathers still withstand bursts of personal power in an era of polarized politics? At the center of the issue is a question repeated throughout hearings and academic debates. Can a president self-declare what is emergency to exercise nearly unlimited power, or must he be subject to oversight and consensus from the legislative body elected by the people? The answer holds significance not only for the Trump administration but also sets precedent for every subsequent president of any party. For if a leader can use a vague law as a master key to bypass Congress, courts, and checks and balances institutions, then the Constitution itself, the supreme foundation of American democracy, will be eroded bit by bit. In the past, America has faced multiple power crises, from Abraham Lincoln's time during the Civil War to the Watergate scandal under Richard Nixon or the detention of immigrants under George W. Bush after the 11th of September. In each of those moments, democratic institutions had to stand up and clarify limits for presidential power. But never has the dispute touched everyday lives so quickly and profoundly as now, when tariff executive orders are not just words on paper but utility bills, shopping carts in supermarkets, or employment contracts in factories. In that context, the role of the courts, especially the Supreme Court, becomes paramount typhold. No longer merely a judicial body, the court becomes the final gatekeeper, protecting separation of powers and preventing democracy from sliding down the path of modern authoritarian regimes, starting with emergency declarations and ending with complete elimination of oversight. Nor can we forget the role of Congress, which should be more proactive in clearly defining and limiting the concept of state of emergency instead of letting presidents interpret at will. Over more than 40 years since enacting the Emergencies Act, Congress has somewhat loosened its oversight role, which is now backfiring on the people's side. This story is a reminder that democracy is not a default state, but a process that needs to be maintained, guarded, and sometimes resisted. Whether a president can impose taxes without Congress may seem like a specialized legal issue, but in reality, it is a matter of citizenship, of the right to representation, and the right to control those holding power. Ultimately, the lesson from Donald Trump's tariff executive order does not lie in whether this policy is economically good or bad. It lies in the question, when executive leaders are ready to bypass constitutional processes to achieve personal or political goals, is the system strong enough to stop them? The United States has been praised as an exemplary democratic model where power is tightly shared among three branches: legislative, executive, judicial. Now, that very model is facing a significant challenge. If it overcomes, it will be even stronger. But if not, then the price to pay will not just be a few $100 billion in taxes, but trust in the institutions,